The main aim of Lawvs is to create a strong legal community where students, teachers, and professionals can learn from each other and grow together. We all know that law is not just something we read in books. Law is something that lives in society. It protects people and it helps bring justice. For law students, it is very important to not only read the law but also to practice and how it works in real life. That is where the moot court competitions become so important. So, the next question comes to your mind would be why Lawvs is organizing this moot court competition? So, I would like to start with a Sanskrit quote that says, Dharmo rakshati rakshitaha. That means law protects those who protect it. So, moot courts are training grounds where future lawyers learn how to protect the law by studying cases, interpreting statutes, analyzing judgments, and presenting arguments. Students learn the art of defending justice. When students engage in mooting, they are not only preparing for a competition, they are practicing how to safeguard the law in real life. So, Lawvs has taken this step because we strongly believe that law students need more than just classroom knowledge to become good lawyers. Reading law books, understanding theory is important, but that alone is not enough. A lawyer must know how to do research, think logically, and argue persuasively, and present confidently before judges. All these qualities cannot be developed by reading alone. They require practice. This is why this moot court competition is being organized. It gives students a chance to experience the real world advocacy in a safe and learning environment. Now, I am going to elaborate some of the benefits of this moot court. First is learn by doing. As we can see, students participate in a moot court. They don't just read the cases, they actually argue them. They prepare written submissions, make oral arguments, and respond to the questions from judges. This practical exercise helps them to understand the differences between theory and application. It teaches them how the law works in practice. Second, develop important skills. The important skills are listed are like legal research, drafting, public speaking, critical thinking, and teamwork. These are the skills that not only prepare students for court practices, but also helps in internships, interviews, and any area of legal profession they choose. Third, build connections. Another important objective is to provide a platform where students from different colleges, cities, and backgrounds can meet. Such interactions open doors to new friendships, collaborations, and exchanging of ideas. Moot court competitions are not just contests, they are opportunities to build a network that lasts beyond the law school. Meeting fellow students, mentors, and professionals helps broaden perspective, gives exposure to different ways of thinking. The fourth benefit is building confidence, and that is a very usual. Standing in front of judges and presenting arguments can feel very scary in the beginning, but one student do it here in the moot in a supportive learning environment, they gain confidence. That confidence stays with them for life, whether in whether in courtrooms, interviews, or public speaking. Fifth is enhance critical thinking. Lawyers must think quickly and respond smartly. Moot courts train students to analyze both sides of a problem, anticipate counter arguments, and give strong replies. It sharpens the mind to think beyond the obvious, out of the box. Sixth, encourage teamwork. Mooting is never a solo journey. Students work in teams, dividing research, preparing drafts, and coordinating oral arguments. This teaches them teamwork, discipline, and collaboration, skill equally important as an individual talent. Seventh, learning professional ethics. In moot court, students learn how to respect the court, how to structure their arguments, and how to maintain dignity while disagreeing. These professional values are as important as legal knowledge. And the next is boost career readiness. Mooting experience is highly valued in internships, jobs, and even while applying abroad. Recruiters and professionals see Moot Court as proof that the student can argue well, research deeply, and work under pressure. These competitions make them better prepared for their careers. Provide equal opportunity. Lawvs wants to give every student, whether from a top university or a small town college, the same chance to showcase their talent. Talent should not depend on the size of institution, but the hard work of the student. And here come the next, building connections and networks. That also means that their students comes together, mentors and judges from different parts of the country come together. They interact and they participate, form friendships and professional connections. And next is encourage healthy competition. Moot courts promote the spirit of healthy competition. Students give their best, but they also learn discipline, patience, and respect for other efforts. The aim is growth and not rivalry. And the next is promote research culture. To prepare for moot courts, students go beyond their textbooks. They study case laws and read judgments and analyze legal debates. This creates a culture of deep research and critical thinking, which is the foundation of legal profession. And last point, or you can say the last benefit of this moot court, uh, shape future leaders. Most importantly, Law VS believes that today's students are tomorrow's advocate, judges, academicians, and lawmakers. Through this competition, we want to help shape confident, skilled, and ethical professionals who lead the legal system with integrity. Here's a quote by Oliver Wendell Holmes, which says, "The life of the law has not been logic, it has been experiences." That means through this moot competition, Lawviers hopes to inspire participants to gain confidence, polish their advocacy, and step closer to become not just lawyers, but responsible professionals who can use law as a tool for justice and change. I would like to end by saying that this competition is not just about winning or losing. It is about learning something new, improving yourself, and preparing to serve justice to the society as a good lawyer. Lawyers believes in supporting the next generation of legal professionals, and this moot court competition is one of the steps towards its goal. Thank you. Now, I would like to invite Ms. Sambhavi to introduce our esteemed guest.
Good afternoon, friends. I am Shambhavi Shukla from the Lawvs team, and I am thrilled to join you at the first National Virtual Moot Court Competition 2025 organized by Lawvs. I am honored to introduce our esteemed keynote speakers. First, we have Advocate Dr. Khushbu Malik with us. Dr. Khushbu Malik is an assistant professor of law at Christ University, Delhi. She has done her BA LLB honors from MD University, Rohtak, Haryana. She completed her PhD in 2021 from Faculty of Law, Delhi University, vis-a-vis Constitutional and Health Law. She has co-edited a book titled Gender Equality, a Multidimensional Approach Towards Shifting Socio-Legal Paradigm in India. She has presented papers in various national and international conferences. She has published 2 patents and 6 plus research papers with IGI Global, IEEE, and other reputed Scopus index books and journals. Her PhD is on emerging trends of telemedicine in India and right to privacy, a critical appraisal. She is having a good experience of teaching at School of Automation and Robotics, School of Design and Innovation at GGIPU, New Delhi, Bharati Vidyapeeth, and Amity School of Law, Noida. She has also rendered her services as Assistant Professor of Law and in BS Anangpuriya Institute of Law, MD University in Faridabad. Besides this, she has participated and presented papers in various seminars and conferences. She specializes in health, criminal law, and data protection laws. Her area of interest includes artificial intelligence, blockchain, criminal laws, data privacy laws, health laws, environment laws, telemedicine, and cybersecurity. We warmly welcome and thank you for your esteemed presence at the first National Virtual Moot Court Competition, ma'am.
Am I audible?
Yes, ma'am. Yes, ma'am.
Okay. So, first of all, good morning, everyone, distinguished judges, advocates, all the teams which have joined us today. So, it is my immense pleasure to welcome you all to the National Moot Court organized by Lawvs. First of all, I'm thanking and giving in heartfelt congratulations to organizing committee, that is Lawvs, and all the media partners for bringing this event to a reality where so many teams are coming together from different universities, different states. So now, students, as you are participating in Moot Court, first of all, let us understand that it is not just any event in one of our academic calendars. You have to understand that these are the closest simulation in a real court. Because when you are participating as students in a moot court, you get to know how the court functions. It is a simulation for you. You know what is simulation? Simulation is a setup where you experiences real experience. So as future advocates, during these moot court competitions, we are giving you a simulation where you can experience a real court, where a student can understand that how they feel when they step into the world of actual practice. So actually we can say that this moot court is kind of a laboratory for us. Why we say laboratory? See what we do in laboratory. In laboratory we do some experiments, we get some results. In the same manner, moot court is like a laboratory where we are giving experience to our future advocates so that they can learn that how you have to practice, how you have to experiment with law, because facts keeps on changing. Law is static. So maybe in one case you're plaintiff, in another similar kind of case you're defendant. So you have to learn, and how you will learn. One thing you learn from books throughout your 5-year journey or 3-year journey, but here you have to experience it, how you have to state everything in a courtroom. You have to polish your soft skills. You have to prepare yourself to face the actual world. Why I'm saying to polish your soft skills? See, as an advocate, how empathetic you are towards your client. What are your communication skills? Whether you are able to explain it to your client, whether you are explain whatever you have to explain to the court or not. The court, the judges may not agree. Sometimes they may agree what you are saying, sometimes they may not agree what you are saying. So you have to persuade them that what you are saying is right, how you have to go by evidences. Everything you will learn in this simulation exercises. Now, when so many teams have joined, everybody wants to be a winner. It's not wrong to be a winner. But understand, students, today's session is not about winning or losing a competition. Understand. It is about discovering or just finding out an advocate which is within yourself. So your future advocates, you have to find out what you are good at. Maybe you are good at drafting. Maybe you are good at making arguments. Maybe your research skills are very good. And when different teams are competing, are participating, you also get to learn where you are missing as a student, where you're lacking in your research, where you are lacking in your drafting. So I'm again saying, students, it's not about winning or losing this competition. It's about giving your 100% in the competition and learning and discovering a lawyer which is already present within you. You have to learn that how you can persuade the bench to agree with whatever you are saying. You have to understand that mooting is an experience. See, in your classroom as a student, you learn what are facts, what is fact and issue, what the law is. You learn different laws, whether it's a procedural law, substantive law. You learn how various Supreme Court, High Court cases, there may be some conflicting judgments. You learn how to cite cases. Now, when you've learned so much in a law school, or you're in the process of learning so much in the law school, when you actually go to a court, the law all of a sudden becomes alive. The facts begins to matter. You have to argue. You have to counter argue. So in this mooting competitions, what you learn that how the law will become alive. So I'll share some actually real life examples with you without naming my students. See, I am into practice and I'm also teaching as a visiting faculty. So I have experience of both. What you face in court, what you face in the classroom. The classroom I face that sometimes the students are very hesitant to speak. They are very introvert. So what I suggest to my students is that you first take part in your classroom discussions. Secondly, every law school and so many law firms, they organize moot court on regular intervals. Participate in those moot court intervals. Maybe this time you don't win, you just lose. But you have taken one step in breaking your hesitance and speaking in front of so many people. See, you're one among us. We're not here to judge you. We are here to polish you. So I know many students of mine who are very hesitant in speaking in the class. So I and other teachers, we motivated them to participate in various moot court competitions and other competitions. Gradually, in maybe first 2-3 competitions, they lost and then they started winning. Sometimes a third position, second position, first position. And ultimately, they realized that after 5 years, now they're confident. They can speak anywhere. And when they actually started practicing, after completing their degree, they felt that whatever confidence, communication skills they have learned through these moot court competitions is actually helping them in their real court practice. See, with these competitions, we are not actually only teaching you how to make arguments. You have to make your memorial. So you have to learn discipline. There's a deadline given to you that by this date, your memorial has to be submitted. So we teach you discipline. We teach you respect. When you part in these competition, we teach you that how it is important for you that you have to respect your opponent. You have to respect every deadline. If your case is listed on some day, you have to argue. You cannot just say, I am not ready for the case. Then you have to respect the law. You have to respect the bench and you have to respect the opponent and the party who has come to you for seeking justice. Now, sometimes we feel that what students are doing is they're copying memorials. No, students, kindly do not copy your memorials. It's a lab where we're teaching you to be lawyers. If at this nascent stage you start copying, you will always depend on somebody to make your brief. So please make sure you have to keep certain points in mind when you're participating in a moot court competition. First, you have to make sure that your moot memorial is original. You're not copying any content from anywhere. Because if you're copying, you're committing plagiarism. Then know your case. Just read your problem several times before coming to the competition, before making your memorial. You will realize when you're reading your problem for the 5th or the 6th or the 10th time, your opinion might change. Your opinion might change how you will pursue your case in the court. Then what we see is that Students, they just read their case from their brief. Just don't read your case. Know your case. Remember every fact of your case. So this is very important that you're remembering every fact. Understand. Mooting is an art. Art of what? Advocacy. It is an experience. The more you participate, the more you learn, the more your skills are enhanced. You start developing a clarity of thought. You start appraising the facts. You strengthen your logical reasoning. You start articulating your arguments in a manner that people start agreeing to you. Understand, student, law is not static. Law has to change. For example, now we are every day talking about AI, blockchain, data protection. You every day see that somebody is somebody is doing a cybercrime against you. So by each day, law is evolving. You as an advocate also have to involve. You have to understand that how you will understand complex legal problems. So if you develop your understanding of understanding complex legal issues, you will become a distinguished good lawyer. And Moot Court gives you that opportunity how you can become a lawyer. Actually, see, we like science students, we don't have any practical labs. So basically, mooting for advocates or future advocates is a lab where your whatever theory you have learned in your classroom is actually put to practice in a simulation of a courtroom. So this, understand, students, for today, whether you are taking a trophy or not is not important. What important is that next time when you're participating, there's a transformation in you. There's a transformation in how you're disciplined, how you're managing your time, how you're doing your teamwork, how you're respecting the bench, how you're respecting the opponents, what textbooks you're following, what online resources you're following. And also understand, as we are globalizing, we have to understand that this is social reality that you can practice cross border. We are coming up with problems of international law, commercial arbitration, human rights violations, constitutional challenges are there. New areas are emerging like AI regulation, blockchain, environmental protection. So you have to be you have to enhance your skills as we are globalizing. So now, students, I extend my, first of all, again, I extend my congratulations to Lawvs for giving you all this opportunity by organizing this event. And my best of luck to each and every team which is participating in this event to show their best potential, and may the best team win in this competition. Thank you all.
Thank you, ma'am. Now I would like to introduce Advocate Dr. Rakesh Malhotra. Advocate Dr. Rakesh Malhotra, sir, a distinguished High Court lawyer, is well recognized for his relentless dedication to public service and social justice. Closely associated with numerous NGOs, he has earned a reputation as one of the leading voices in public interest litigation and a famous lawyer in India. During the challenging times of the COVID 19 pandemic, Advocate Dr. Rakesh Malhotra filed several impactful PILs, ensuring that oxygen cylinders, essential medical facilities, and life saving support reached lakhs of people in need. And High Court of Delhi was pleased to pass effective orders to help lakhs of people in India. His legal acumen, combined with humanitarian concern, transformed the way the legal system could respond to an unprecedented health crisis. Respected among his peers for his humility, professionalism, and supportive nature, Advocate Dr. Rakesh Malhotra is especially known for his expertise in medico legal matters, where his balanced approach bridges law and healthcare. His work continues to inspire young lawyers and strengthen the bond between law and social responsibility. We all welcome Advocate Dr. Rakesh Malhotra.
Good afternoon to everyone. Thanks for your appreciation. I think everyone is able to hear me. First of all, I appreciate the initiative taken by Mr. Vishnu Sharma for holding such a conference, and I'm thankful to Sambhi Shukla for praising or for giving so kind words. Now, since we are belonging to the legal profession and all the lawyers who have joined or who are going to join this profession, I'll only say the thing that in our profession, first of all, what we have to focus and what we should do, that is a major issue of concern, because some are the first generation lawyers, some are the lawyers who have their family already into the litigation, practicing lawyers, and or maybe the judicial officer's son. So starting from that perspective, because that stage starts from the college itself. The lawyer who's the first generation lawyer sees the other colleagues or other co-students who are having family of background of lawyers. So please don't come into that trap, because ultimately it is the quality, ultimately it is the sincerity, ultimately it is the discipline, ultimately it is the knowledge, ultimately how you present your case before the court that matters. When you appear practically and you place your arguments in a court, so your presentation makes everything. There is always one man who is noticing you. Either it is a judge, or it is a court staff, or it is a police official, or your colleagues, or the person litigants who are standing or sitting in the court. Someone is watching you. So when you present your case good, irrespective of the results, whether you have obtained the results or you have not obtained the results, but your efforts, your sincerity, your homework get noticed, and ultimately one day any one of them may contact you for or given an opportunity, and that opportunity combined or means to say jointly with your consistent efforts will make the results very positive. So what I have learned in a few words I can share, because there are so many persons who are going to speak in this. I will not waste the time. What I'll say कि सबसे पहला in our profession is this: there's no junior senior in our profession. Any junior can bypass or can go miles ahead than his senior. So you can respect your senior only limited to the extent that he's your guru, but don't take him as a milestone. You can achieve much more than him. So make your mind whenever you join any senior or any law firm, you learn whatever you want to learn and learn maximum. Go through the files, read files exactly the way your senior is reading. Sit in the court, not in the library or not in the canteen, and hear all other lawyers who are making submissions, so that you can gain the knowledge or words, how to speak, what to speak, and the court mannerism. And when your senior, the file which you have read, how your senior is presenting that same file before the court, you will see the difference. What you would have done instead if their senior was not there, then you will see the difference, then you can catch, and that is an experience what you can take it from those briefs. And secondly, after some time, if we are doing well, so this is a field what I said, we have seen in our career, junior are doing much better than the seniors where they have come from the chamber. So you can do. So the necessity in our profession is, number one, starting from first you need a brief, the case. The second part comes the preparation, how you go through that case. The third part comes the knowledge of that subject, whether it is arising from a criminal case, or is it arising from a civil case, or is it arising from some human right or medical laws or something. You should have, now you have Google with you, that can give you uh, many immediate assistance in getting the knowledge. But don't depend upon Google alone. Make research, find laws on that subject before making any suit, plaint, or complaint. Once you are know about the law, that this would be the hindrances, suppose I'll file this kind of suit of the other party, what kind of defense the other party will take. The defenses generally are either on legal side or on the factual side. So legal side, you are responsible. Factual side, your client is responsible. But you have to take the brief, you have to take the briefing from your client very diligently so that you should not miss any point which you should have incorporated, or tomorrow the client would say that you have not incorporated, but I told you. Now we have a WhatsApp communication, we have an email exchange between the, so everything is in writing. So tomorrow your clients can say that you were irresponsible. I told you, I sent an email to you mentioning that these facts, but even then these facts are not mentioned. And ultimately, God forbid, suppose you lost the case only because those points were not taken in your suit or petition. So what I mean to say, the law and the fact should be, you will do the homework first before presenting any complaint or before starting defending any your client. And thereafter comes the discipline. You should be in the court prior to time, means the court starting time is 10 in district courts, in high court it is 10:30. So you should be there in the court quarter to 10 or quarter past 10 in high court, suppose you are appearing, so that there is no stress of that. You have to reach the court, matter is likely to be called, otherwise your presence of mind will go. The next point comes, you should have a short note with you whenever the matter is called. Don't start only switching over the pages. You should know what is written on which paragraph at which page, and there is a short note which should be in your mind. Prepare all the case in night and have a revision in the morning, so that page number, para number, and dates, you should be ready with the page. I have seen so many lawyers, even they don't see the files, but they are very much conversant with the facts of the case, and they can speak half an hour, 1 hour without opening the files. So means you have to do your homework with respect to the facts, with respect to the briefing, and thereafter part comes, you will put your case in a court. Suppose you are a petitioner, you will put your case in a best way, whatever the best way you can do, in a well dressed and well mannerism, the court mannerism, by making all the respects to the court. And now the opposite party comes and opposite party makes the submission. Don't make all the submission at the first instance when you appear at the first instance. Keep 25% of your argument in your hand and make only 75% of your submissions in the first go. Let other party opposes your petition or make their stand. Keep that proposition in the mind, whatever the opposite party has made. Write it on a paper. Deal it point wise when your rebuttal comes. And then the 25% of the points which you left in the first half, the first time, then place it along with the rebuttal. Then the court will be, there are chances the court will be on your side. So this is the how you have to present your case before the court. And matter does not end here. Now what we are saying, that most of the lawyers who are the young lawyers, they are very good in argument, they are very good in research, they are very good in pleading because they have a good command over the language. But slightly somehow, somewhere, they are not as good in the cross-examination or on the part of the evidence, because evidence comes in the later stage. Initially, in a civil case, pleadings come first, and thereafter in criminal case, bail comes first, and after filing of the charge sheet, cross-examination stage comes later. So the second stage of any litigation is the cross-examination of the evidence. Prepare cross-examination, what question is to be asked, what question is not to be asked. Prepare that questions and keep in mind what is the going answer, what is the expected answer from a witness to whom you are putting a question. Prepare for that question. Understand what is going to be a defense of the case. Understand what suggestion you have to give to the witness. Suggestion means the defense you have taken in any litigation. That is the suggestion you have to make before to the witness to say. And thereafter, the matter comes for the argument. So you have to be prepared for the arguments, again going through the complete file, which includes the evidence as well as the documentary. Now that this is the how the court works, but how the lawyer should work and what are the difficulties lawyer can face during the course of the litigation, that is the most difficult part, the experience, how you have to deal with the clients, how you have to deal with the some of the courts which are not good with the lawyers, how to deal with the suppose you're losing, your points is not being appreciated by the court. So how to deal with that kind of situation? Because once you are a first generation lawyer, or even otherwise, you are ambitious lawyer, you are met with the failures, your client is not getting relief, the frustration or anxiety or depression starts coming. So you have to come out of this also. So, and this you can come only on those circumstances. Yeah, you should believe yourself that you have a very good case, you can deal it with, and you have very good points to make submissions. So better to locate or to look out for the case laws or the judgments which you can find over that point, which you think is the best point in your defense. And at least what I'll say, what I'll recommend, don't depend upon the, don't put your case only on single point submission. Always have 3 to 4 defenses in your mind. Means you should have 3 to 4 cases fold, or otherwise 3 to 4 fold arguments. Suppose one is not bought by the court, the second one should be, the third one should be, and the fourth one should be. So this I'd say, this you have to see. Now, what I am requested by someone during the course of the lecture, which I give otherwise, during the course of some conferences or otherwise. Now we have various fields. When we started our field, there was only civil and criminal law. Now we have specialization fields, the copyright, the medical laws, the cyber laws, the insolvency petitions. So better to, or international law, because now we are joined with through this internet with all the persons across the world, so we can have a litigation, we can have arbitration, irrespective whether the city is Hong Kong, whether the city is in Dubai or is in Singapore, is in UK or is in America, we can do it by sitting in India. So you have to be concerned with the international law. So what I'll say, better to have a specialization in one field, have a exposure in that field for 2 to 3 years, and thereafter open your law firm. And that field, if you have an interest in so and so field, I started my practice doing civil criminal law both. But on one day, I got one medical law case. I argued, it got succeeded. Thereafter, my line has changed. Now I am much more on medical laws, mostly almost all the hospitals and nursing homes of Delhi and the doctors' associations. I am representing them before almost all the courts in Delhi as well as outside. So we saw the vacuum, and still vacuum is there, but that is a medical field. So choose any field which is comfortable to you, which is comfortable to your language. The language means what you can get easily understand, and you say. And what I am saying, so now there is the insolvency, IBC law has come, which 138 law, it is old law, but 138 still evolving now. So there is a narcotics law, there is this ED law, PMLA law. So you can choose any law and you will find it much easier as compared to the civil or criminal law, what we are doing. Because in those particular laws, there are limited judgments available. Suppose I'll say on medical law, there are maximum 200 or 300 case laws. But when you find IPC in any Google or something, you will find lakhs of judgment over that subject. So you will not able to understand, or you will not able to grab all those judgments in a short span of time. But suppose you want a PMLA judgment, you will get the 300 or 400 case laws over it. A maximum 60 to 70 celebrated judgments of the Honorable Supreme Court. So you can choose any field, you can be a master at this stage, and ultimately after 10 to 15 years, you will be king or queen of that time. So in my opinion, choose the specialty field diligently, go for it. And now concluding my short advice to all my colleagues who are going to be colleagues soon. So best wishes from my side. So kind of means at the end, I'll only say discipline, file reading, preparing the case well, arguing the case well, think before what you have to speak to the court, make a rehearsal initially, unless until you have experience 2 to 3 years of the court. Think your arguments, what would be your arguments before the court, and just suppose that what are the probable questions the other party or the court may ask. Get prepared for it. Otherwise, you will regret after the matter is over that why should I fail to said so, why I could not able to remember that point. why I should have gone through the judgment well before presenting my case. So do all homework before the case. After that, no one will ask you, or whatever you will say, that will be only an excuse or regret. So prepare your case well, go to the court well dressed, well language, and don't dishearten. Suppose you are lost your case, it happens with everyone. So take it lightly and convince your client that you are going to do it. So confidence is the major component are in a legal fraternity. You have to deal with the judges, you have to deal with the police, you have to deal with the authorities. So be strong and always have a courage. You should not be afraid of anything. Suppose you are finding something wrong is being happening either in the court or outside the court, you should have a courage to raise your voice, to come for the rescue of the person who need your help. So always be helpful for everyone. Suppose you are seeing that your fellow colleague or your junior or your senior is struggling with some case law, he is not getting it, please help if you have your knowledge. Always become a member of the groups where the knowledge is being shared, where the later judgment is being shared. Go through the later judgment. Please make a register or a short note or a file in your computer. Put all the judgments on a subject wise on that folder, because today you are getting a judgment of section 116 of Evidence Act. Probably after 5 years you will find yourself in the same position. Then you have to find out that case law. So better to maintain a register so that you can do it immediately, or you can help your colleague immediately. So start preparing all the notes of the judgments in your computer or register. In our time, we used to maintain register. So please do these all things that will come into the practical way of your practice. So I'm concluding here. All the best for your future endeavors and your profession. Thank you very much. Thank you.
Thank you, sir,
Thank you.
for your helpful and considered insight. Now, I would like to invite Advocate Madhav Goswami, sir, to address the participants regarding the Moot Court participation briefing. He has participated and won awards in over 20 Moot Court competitions. He also organized National Moot Court Competition in GLA University last year. We warmly welcome Advocate Madhav Goswami, sir.
A very warm greetings to everyone, including distinguished guests of the competition and the inaugural ceremony, the organizing committee, founder and chairperson of Lawvs, Dr. Vishnu Sharma sir, and the entire participants who have participated in this competition from different law institutions across the country. I welcome you all to the enriching journey of the first Lawvs National Virtual Moot Court Competition 2025. So basically, I'll be briefing you about the rules of the competition. Although all the rules are given in the brochure of the competition itself, but I'll be briefing or summarizing them very quickly. So the competition will evaluate you in three aspects. The first aspect is oral rounds. That is for the speakers. Second is the memorial. That is for the entire team, which are your written submissions. And the third is the researcher test, specifically with regard to researchers. So if I talk about oral rounds, the entire competition is divided into various rounds, including preliminary rounds, which in turn is subdivided into prelims 1 and prelims 2. So each team will be getting a chance of representing both the sides, that is to say petitioner and respondent in the competition. Upon the highest cumulative marks obtained by the top 8 teams in the it's for now quarter final round, which will be qualifying for the final rounds, are two. Basically, the quarters, the semi-final and the final will be knockout in nature, and the preliminary round will be cumulative round in nature. After this, the memorial evaluation will be made by the concerned expert, and the team which will be getting the highest mark will be rewarded as the best memorial. After this, the awards for this competition are divided into various categories. The first category is winner. The second category is runner-up. The third category is best memorial. The fourth category is best researcher. And the fifth category is
Good afternoon, everyone. Am I audible to all? Please thumbs up. As we come to the conclusion of our inaugural session of first virtual National Moot Court Competition, which is organized by Lawvs, it gives me immense pride and joy to reflect on this journey. This competition is not just only the test of intellect of young law students, but also give them the opportunity to sharpen their courtroom skills and prepare for the noble profession that lies ahead. I would like to begin by extending the heartfelt gratitude to our esteemed knowledge and support partner, which is GNIT, Live Law, LexisNexis, and Manupatra. Our association and encouragement have added their immense value to this competition. These platforms have always stood as pillars of our legal education and access to the knowledge. And today, again, we provide how deeply you committed the empowering the next generation of lawyers. A very special appreciation for Lawvs, which has been considering doing wonderful things for the welfare of legal fraternity and young law professions. Lawvs has not just organized a competition but created a platform for going mentorship and excellence. The initiative taken here is a step towards sharpening professional is created a platform for growing mentorship and excellence. The initiative taken here is a step towards sharpening better profession, better advocates, and better leaders for tomorrow. I always take this moment to express our sincere Dr. Khushbu ma'am, who has instrumental in guiding our young participants simply by simplifying the complex moot court concept and inspiring them with her clarity and grace. Ma'am, your efforts have made a lasting impression on every building lawyer present over here. Equally, we are deeply thankful to Dr. Advocate Dr. Rakesh Malhotra sir, whose wisdom and encouragement have been a source of great motivation. Sir, your contribution in nurturing our young lawyers and sharpening such wonderful insights will forever remain valuable in professional journey. Finally, to all participants who are the true stars of this competition, each of you do hard work, dedication, the courage of to present your argumentation. Whether you want, whether you won or not, you are taking back something far more important: the experience, the learning, the confidence to move ahead in your career. Let us remember that this is not the ending, but the beginning of many such endeavor. Law VS is committed to providing platform where knowledge meets the opportunity, where talent meets guidance, and where the legal fraternity stands united for cause of justice and progress. On the behalf of Lawvs and everyone associated with this competition, I extend warmest congratulations to participants and the best wishes to all the bright future. Thank you once again to our partner, mentors, judges, and participants for making this competition on a memorial successful. This with this official declaration, the first national virtual moot court competition it starts and will begin by today, and the number of stars are on one roof. Now, I would like to say Madhav will continue with the remaining topics which were already remained. Now, Madhav, please continue.
Am I audible now, Shivam?
Yeah, Madhav, you are completely audible. Please.
Sorry, there were some network issues on my
No
part.
issue, no issue. Please.
Actually, what I was saying is that the competition which I have discussed with you will evaluate you in three parts. That is to say, first oral rounds, the second is memorial, and the third is researcher. Furthermore, I have told you that the entire competition in perspective of oral round is divided into several rounds. That is preliminary rounds, which is further subdivided into 2 rounds, prelims 1 and prelims 2. The second is quarter final. The third is semi-final, and the fourth is final. The preliminary round will be of cumulative nature. That is to say, the results of quarter final, which means the team which will be qualifying for the quarter final, will be decided on the basis of the highest marks obtained by the teams in the preliminary round itself. And the number will be 8. The team which will be qualifying from quarter to semi will be 4, and the team which will be qualifying from semi to final will be 2. From quarter to final, the round will be of knockout in nature. For example, if there in a courtroom number 1, there is team A versus team B. So the team which will be getting highest marks from the judge in that courtroom will qualify for semi-final. That is the meaning of knockout round. After this, the memorial evaluation will be made by the concerned expert, and the team which will be getting the highest marks in memorial will be rewarded with the award of best memorial. Apart from this, the 2 awards are there. That is, first, best mooter. The best mooter will be given to the team which will be obtaining the highest marks in the preliminary round itself, so that each team receives a fair chance of getting this prestigious award. After this, the last award which is remaining is best researcher. The best researcher will be given to the researcher of the team which will be getting the highest marks in the researcher test, and your researcher test will be conducted today itself, and from tomorrow your oral proceedings will start taking place on. So I wish very best to all the registered teams of the first Lawvs National Virtual Moot Court Competition. May the best team win. Thank you.
So I would like to conclude the event by thanking all the participants who are present over here. This is all because of the participants. We are standing here in this platform due to your support. Thank you all. And all the best to all the participants. Just give your best. This is not winning or losing. It's all you give from your side. Thank you. Signing off, Shivam Kumar from Lawvs.